So good afternoon, everyone, and thank you for joining us in this important webinar on the title Ethics of NDA in Sexual Harassment Settlements. I'm Cristiano Cominotto. I'm an Italian lawyer of Assistenza Legale in Italy, but most important, I'm the co-chair with Wayne Outten of LAINI, that is a group of lawyers who are dealing in the matters of executive and employee. This is a great privilege to moderate this session today. Our discussion will explore the complex ethical implication of non-disclosure agreement in cases of sexual harassment. We will have an international point of view. We will hear from USA, UK, Canada, and part of Europe. I think that the panel that we have here with us today is really important. These are the people who are going to talk today. They are among the probably the most prepared lawyer that we have in this field. Plus Zelda Perkins, and you know, I think that everyone knows her. She's the co-founder of Can't Buy My Silence, and she's also a former personal assistant of Harvey Weinstein. And she is at the forefront of the movement to limit the use of NDAs. We will also hear from Julie Morris. I would like to thank you a lot, Julie Morris, for everything she did to organize this panel. She was very helpful. So Julie Morris, partner at Keystone Law in the UK. There will be also Menaka Fernando. She's a partner at Outten and Golden in the USA. And also, last but not least, Emma Phillips, partner at Goldblatt Partners in Canada. So each speaker will bring us a unique perspective on the use of NDAs across different jurisdictions and the movement to regulate or ban their use. Before we begin, I would like to remind you that for anyone on the call who is considering legal action, no information shared during this program should be considered as legal advice. I will introduce Zelda Perkins. As I say, she's the co-founder of Can't Buy My Silence, a campaign to ban the misuse of NDAs. And this campaign was born out of Zelda's own experience having signed an NDA with Harvey Weinstein. Zelda, to begin, could you tell us what your experience of this process was like?
Sure. Thank you very much for having me here today. And I apologize for those of you who may know some or all of my story, but I'm going to tell a little of it for those who don't know, just as an example of what we think is a historically egregious and unethical NDA, but unfortunately is a perfect example of how NDAs can and are still being used. I was put in a position of negotiating a settlement agreement with Harvey Weinstein after he sexually assaulted my assistant in 1998. My initial response to that happening was to report what had happened, and I presumed that justice would be served. I think naively, as a 24-year-old and a white, well-educated, middle-class girl, I presumed that the pillars of the British justice system would protect me, and that by reporting a criminal offence, I would have immediate access to justice. Now, I was disavowed of this very quickly by my own legal team, not by the company or Harvey's legal team, but by my own legal team, who told us that we essentially weren't in a position where we could seek justice because it would be our word against his, which would be my first understanding of the power and justice dynamic, which I'm sure you're all very aware of, but as a 24-year-old, I really wasn't. This led very quickly to negotiations, of which I was very, very strongly felt that at no point should money change hands, because that would change the balance of the agreement. However, we were told initially that for me, the agreement was about stopping Weinstein's behavior, because the only legal tool that we were given to do that was this damages agreement. And I was told by my own lawyers that that's not how it worked, and that the first thing we had to do was ask for a financial settlement. And then if we really wanted to negotiate these unreasonable demands, which my own representation thought that our demands were, which were that Harvey Weinstein had to go to therapy for sex addiction, that the company Miramax had to bring in a new HR policy, that if Weinstein, Miramax was owned by Disney, tried to settle with somebody again in the ensuing 3 to 4 years, Disney, the parent company, would be informed, or Weinstein would be fired, that he couldn't travel with female assistants. We put in all of these clauses in the hope of stopping his behavior. Now, once we were told that we had to accept money if we wanted to get to the negotiation table, then in my eyes, this became about that money was indicative of the crime. So we got a large settlement. We got $125,000 each. And to me, that was indicative of the crime. And I also presumed, as it was a legal document, that this legal document would be of record, and that this would show that something terrible had clearly happened. So that was my own naivety. But it was the only course of justice that we were offered. We were told that if we tried to go to court, Weinstein would bankrupt us, our families, any skeletons that were in the closet would be brought out into the open, and this really was our only option. I appreciate that myself and my assistant were very young. We were both 25 under, and this was our first experience with lawyers. Not only that, we were then taken through what I can only describe as a form of legal waterboarding. We were taken to the offices of Weinstein's lawyers, who were a Magic Circle firm, Allen and Overy, and we were generally taken there after hours, which was quite intimidating for us. We were kept in a room. Often we were isolated from each other, where we were not allowed pen and paper. We were escorted to the loo. We had to ask quite forcibly for refreshments, and we were made to feel like we were the problem. We were put under a lot of time pressure, and it was a very adversarial environment, and one that we really didn't know how to cope with. Now, I'm telling you this from a position when we were young women, but this is still how negotiations tend to happen in settle agreements. Okay, it might not be done by Allen and Overy, it might be done by your in-house counsel. However, the techniques of negotiating settlements are what cause almost more damage. And this is something that we see at Can't Buy My Silence on a regular basis from the testimonies that we get from people who have signed NDAs, that the negotiation process in itself becomes more of a trauma and has more of a long-lasting psychological impact, not only on their personal emotional life and personal relationships, but also their professional life. And I think that this is something that, understandably, lawyers are not going to be aware of. You know, they go into a situation where they are having to choose between, essentially, their employer's instructions and reputation and the integrity of law. And I think this often, the integrity of law, gets lost sight of in these negotiations because of the adversarial nature. And I think the majority of lawyers in this situation don't understand the client experience. And there's no reason that they would, unless that's something they themselves have been through. They're very unlikely to be trauma informed. And the majority of people who are coming to a case like this will be in trauma. So they are having issues with memory, they're having issues with fear, they're having issues with retaliation, they're vulnerable and certainly not equipped to deal with a high pressure adversarial negotiations. I think when I talk about my NDA, people, tend to shake their head and say, oh, well, they don't make them like that anymore. So we had to use our best endeavors not to speak to the police or another lawyer in a civil, if there was a civil case. We had to give Miramax and Weinstein 48 hours notice if we were approached by the police or a lawyer. We were not allowed to speak to the UK tax office about our settlement. We were not allowed to speak to a therapist, a doctor, our family, a priest. We were not allowed to speak ever about our time at Miramax. And for me, this had been 5 years of my career, my first career. We also had to create a schedule explaining who we might have shared information with, and if any trace of the information that we had told that person came to light via the person in the schedule, we were the ones who would be considered liable for that. So we were kept in a, it was a Kafkaesque situation that we could not win from. Now, we also had perfectly good independent lawyers, including counsel. So this was not a case of us just being two girls who didn't know what they were doing. We had adequate representation, in fact, more than adequate. We had counsel from a very highly regarded human rights chambers. And yet we still signed an NDA that is completely unenforceable. Completely unenforceable. The majority of those clauses are unenforceable. Yet at no point did one of the lawyers in that room tell one of us, two young vulnerable women, one who had suffered a violent sexual assault, that these clauses were unenforceable. Now, I see NDAs on a weekly basis that are being made still today that contain unenforceable clauses. Because of the nature of NDAs, because people don't get to see them, you can put whatever you want in them, because the likelihood of a victim having the psychological or financial wherewithal to test their agreement in court is very unlikely. I think over the last 30, 40 years, NDAs have worked very well in being a sort of standard secret agreement. I think what we're now seeing in the last 5, 6 years since I've been talking about this is that the whole dynamic between risk, reputational risk of having an NDA to silence people, and the fact that now having an NDA could be a red flag is changing. That risk equation is changing, which is a really good thing. But it has taken 7 years since I gave evidence to 2 select committees, gone through 2 investigations with the UK Solicitors Regulatory Authority, who have also put out 3 warning notices in that time about the misuse of NDAs. Our legal oversight regulator, the Legal Standards Board, also has done a study showing that NDAs are being misused. For me, this was always about changing legislation and regulation. You can't change the individuals, but if the law is being used abusively, then we're really in a very difficult situation. I just want to give you a couple of examples of cases that I've been dealing with recently, and this is in the last 12 months. I'm dealing with one woman who is being put under a lot of pressure by her own representation, who's a pretty well-known feminist lawyer, to sign an NDA. And within that NDA, she is not allowed to use specific vocabulary for the rest of her life. She was sexually assaulted by somebody who has a public profile. And as I say, her own lawyer is putting her under pressure to do this and saying, if you don't sign, you won't get your settlement. I know that we're going to, our lawyers here are going to discuss the realities of that and the fact that this is actually the wrong equation. A settlement is about your entitled settlement money. It is not about being paid to be silent. And I think that's become standardized in the legal sector. And I think a lot of lawyers don't even think about that being uncoupled, but it really needs to be uncoupled. Another example of a woman who was going through negotiations again on a settlement, and this was to do with maternity discrimination and bullying. Whilst she was during the negotiations, she became very ill and was hospitalized because she made an attempt on her own life. Whilst she was in hospital, her lawyers and her employer's lawyers approached her to sign and pushed her into signing her NDA. Now, again, when you look at it from this very simple side, you can see the unethical behavior there. But in terms of the lawyer's narrative, it's that, you want to get this over, you want to move on, things will be better once you've signed this. When you are in that very vulnerable state, it is almost impossible, if you are being offered a huge amount of money, to say no. And this is why this really has to be taken off the table. And this is totally possible. And we can see this from what's happening in the States and what's beginning to happen in Canada, but particularly in the States. And the campaign that I run, Can't Buy My Silence, we've been campaigning and lobbying hard in the UK for legislative change, and we're getting there very, very, very slowly. But to me, still, the legal sector is dragging its feet. Ultimately, I feel that lawyers need aid and assistance from their guidance regulators so that they do not have to take the responsibility of making that ethical decision where potentially the person who's also paying their wage will be watching how they deal with a victim settlement. I think one of the other things that's very important for people to understand when talking about confidentiality is that everyone tends to see it from the perpetrator's point of view. But the reality is as a victim, if you're made to sign something, that means that you have a basic human right taken away from you, which is being able to speak about your own trauma, which you need to be able to do to heal. Not only is that being taken away from you, but you have long-term feelings of guilt and complicity in continued abuse from the person who allegedly or has abused you. And I don't think there's been enough, I think there's beginning to see enough exposure of what this really means and the long-term effect this has on not just the human beings, but the companies that these people work for, and the long-term damage that it creates if you are working in an environment that does not keep you safe. So again, that risk equation of looking after your employees or silencing your employees is changing. And I think we're going to see some great examples from Emma, Menaka and Julie about that. And I'll stop banging on and hopefully I'll be able to answer some questions afterwards.
Zelda, what you said to me, it's really, really interesting because when we started to think to this webinar, I spoke a lot with Julie Morris about the European situation. I remember that at the beginning I told to her, well, we don't have in Italy this kind of problems, not even probably in France, in Germany. And we wrote to some lawyers in France, in Germany, Julie and me, and mostly of them responded, yes, we know that there are people who are signing NDA in France, in Germany and in Italy, but we are not talking about this issue. And the point that I was saying is that these kind of agreements are not enforceable, for example, in Italy. But the point is not if these kind of agreements are enforceable or are not enforceable. It's about how you manage to feel the people who are signing this agreement obliged to follow this agreement, how you can totally wreck the people, disrupt the people. That is about, not just the legal terms. And that's what to me in Europe we still didn't understand, and that's really important. That's why your testimony is so important for us and for even UK, USA, and Canada. So thank you very much, Zelda. Is there anything else you would like to add?
I wanted to agree with you because I think, as you say, it's really almost irrelevant whether the NDAs are legally enforceable or not, because the amount of fear and the coercive pressure that are put on people to sign them has the action of making them completely enforceable. And I think you can see that from the recent case with Fayed, that nobody felt free to speak or break an NDA until he was dead. And this is very common. But yes, thank you. That's a very, very good point.
Okay. So let me introduce our next speaker, is Julie Morris, partner at Keystone Law in the UK. I've already presented you, Julie, so go ahead.
Thank you, Cristiano, and thank you, Zelda, for sharing your experience. It's really powerful to hear in person, and it holds the light up to certainly how it feels on the employee side to have signed an NDA. Also want to commend Zelda on the immense amount of work she's done in moving this debate forward in the last 6 years. And certainly, you know, her with Julie McFarlane in Canada, she spearheaded this campaign, and to highlight to all of us the impact of signing NDAs. Now, apology to the UK lawyers on the call. I just want to briefly talk about the history of the regulatory and legal position in the UK for those who are in other jurisdictions. So after Zelda's compromise agreement and others came to light, in 2018, the UK Parliament held an inquiry into the use of NDAs, which Zelda spoke at, and I did as well. And that led to a number of recommendations, but not a recommendation of an all-out ban, possibly influenced by the fact that the body representing employment lawyers in the UK said that 95% of their members didn't support an all-out ban. As a result of the recommendations, the body governing solicitors in the UK, so I'm going to call that the SRA, they issued a warning notice to solicitors about the use of NDAs. That warning notice has been amended over time, but it makes clear that an NDA would be improper if it sought to prevent an individual from reporting an offence to a law enforcement agency, cooperating with the police or a prosecution, reporting to a regulator, whistleblowing, making any disclosure required by law, and speaking to professional advisors, which would include legal and medical advisors. But it also stated that solicitors have a duty not to take unfair advantage in situations involving the use of NDAs. Now, concerns came to light that NDAs were still being used inappropriately, and I know Zelda had a hand in that. And there are a number of resulting investigations. And the SRA, when it did its investigation, found that only a quarter of firms they investigated had ever questioned a client on whether the inclusion of an NDA was appropriate. And they found that the vast majority were using templates to draft them. As a result, they issued further guidance, that was earlier this year, which said NDA should not be used routinely, and a solicitor should consider carefully if an NDA is necessary, given the specific circumstances of the case. And if it is, it should be tailored to the individual, noting that they're often vulnerable and there shouldn't be unreasonable time pressure. Now, obviously, that's just regulation. It relies on solicitors exercising their professional duties to comply. Insofar as actual legislation is concerned, the Victim and Prisoners Act 2024 was enacted this year. This means that for criminal conduct, and obviously that could include a number of examples of sexual harassment, sexual abuse, certainly, any NDA will be void if it precludes an individual, a victim, from speaking to law enforcement, legal, regulatory or therapeutic advice services or family. There's also whistleblowing legislation, which would strike down as void any provision preventing an individual from blowing the whistle. And an act banning NDAs in cases of sexual misconduct, discrimination and bullying in higher education bodies was enacted recently, but its implementation is currently stalled for other reasons. So what else is in the offering? Well, in 2024, the government investigated misogyny in the music industry and sexism in the financial services sector. Both concluded that the misuse of NDAs remains a problem and recommended legislation to prohibit their use in certain types of claims, different in each inquiry, but more or less sexual harassment and bullying. Since then, we have a new government with a stated imperative to halve violence against women and girls in the next decade. Although it's not yet clear what their intentions are as regards NDAs, I know that Zelda has them firmly in her sights next week when she meets Jess Phillips and Yvette Cooper. Over the sea in Ireland, there have been amendments to the Equality Employment Act preventing NDAs with an employee in cases where the worker has made allegations of discrimination, harassment or sexual harassment. And implementation, I understand, is expected this week. So just looking at the arguments against the use of NDAs, they seem fairly obvious, but they silence victims, they prevent them from speaking about their experience, and they discourage others from coming forward. They're usually imposed by those in positions of power, such as employers, on vulnerable individuals, i.e. employees, making genuine and proper negotiation of them difficult. they prevent accountability, they stop boards and shareholders from fully understanding their culture. And an organisation that focuses on a transparent culture that encourages reporting, addresses complaints and apologises for wrongdoing arguably doesn't need NDAs. And with that in mind, regulations have come into force in the UK this week, codifying a positive duty to take steps to prevent sexual harassment in the workplace. So it'd be interesting to see what the impact of those regulations are, because that's trying to encourage employers to properly address to prevent sexual harassment in the workplace rather than just deal with it when it happens. Now, I just want to talk about arguments for their use. I know Zelda won't want to hear this, but these are the limitations of the system. So sexual harassment claims in the UK are brought in the employment tribunal, and the legal cost regime in the tribunal is that each party bears its own costs. While that was intended to allow a risk-free regime that allows employees to bring claims without fear that they'd be on the hook for the employer's legal costs if they lose, the reality is that it means fighting a claim to the employment tribunal with legal representation is completely out of the question for most employees. Secondly, compensation for sexual harassment in the UK is not punitive. The median award last year for sex discrimination claims was £11,000, and the largest element is usually the financial loss. But for an individual who leaves employment and secures alternative employment quickly, they will have little financial loss. And the claim is worth even less for those who remain in employment. That means, for most individuals, the legal cost of pursuing a claim will be far more than the likely award. Then, when a claim is lodged, it's only the fact that a sexual harassment or a sex discrimination claim has been lodged and against whom that appears on the public record. The facts of the claim are usually confidential until the case goes to a full hearing, unless it's leaked beforehand. And then the employment tribunal system has backlogs, and it still often takes as long as 2 years for a case to get to a hearing. Therefore, the stark reality is that whilst most employers don't like facing a claim of sex discrimination or sexual harassment, most will know that it will take so long to get to court, will cost so much money in legal fees, will not necessarily cost that much in the final award, and will be so stressful for the individual that most employees won't do it. So it's the ability to keep the facts quiet that is the reason for a case to settle early, and in my experience, to settle well. And let's not forget that the ability to give confidentiality can I'm not saying this is the case in all cases, but it can give a woman power in circumstances where sexual harassment and abuse is usually an abuse of power. That's why I think the employment lawyer body in the 2019 consultation said that if NDAs were banned, far fewer cases would settle. And certainly that is what most lawyers are telling me now. The reason their employer clients usually settle a sexual harassment complaint early is in order to have an NDA. Without one, they're more likely to wait to see if a case is really going to go to the tribunal or to a hearing before deciding to settle it. And that would mean that for all those without the ways or means or desire to progress a claim, they would have no remedy. So whilst NDAs are clearly a problem, particularly when protecting a serial senior perpetrator, the system in the UK is such that there may be unintended consequences of banning in all cases if the result is that fewer cases will settle. I also believe that there are some cases where an NDA can be more justified, like where a misplaced remark accidentally oversteps a line, where we're dealing with no abuse of power, potentially, or where the victim themselves wants confidentiality. But that doesn't mean I think they're appropriate cases at all. So what can we do? The debate has moved on since 2018 substantially. In the UK, settlement agreements, in my experience, almost always now contain the required exceptions. But NDAs are still always appearing in the first draft of settlement agreements, and they're usually made a prerequisite to settlement, most especially in sexual harassment cases. Now, the SRA's warning notice requires solicitors to consider if an NDA is necessary. I think almost all employer lawyers still think that in a sexual harassment claim, it's in the best interest of their employer client to have an NDA, and therefore it meets the SRA's test of being necessary. And let's not forget that they have and want to continue to retain that organisation as a client. And it then takes a brave employee to play a game of poker and insist on its removal in order to discover if the NDA really is an essential condition of settlement. So, if employers and employer solicitors are going to be convinced not to insist on NDAs without a legal ban, they need to see the risks of including them or the advantages of not. So I'm going to give you one carrot and stick on how we might do that. Breaking NDAs. There's a growing movement towards breaking NDAs, particularly where there's a critical mass of victims. And where that happens, the publicity fallout is massive if it comes to light that the NDAs were used to cover up the actions of an abuser. Harrods are finding that out now to their cost, following the Al-Fayed revelations that Zelda's referred to. We have the recent case of Crispin Odey. He owned a hedge fund in the city, resulting in the hedge fund closing down. The Confederation of British Industry also faced similar problems when its NDAs came to light. A recent decision, the UK Supreme Court said that breaching NDAs may be lawful if doing so is in the public interest. So the question is, how many complaints of sexual harassment does it take for it to be in the public interest to make them void? Employers should certainly be thinking twice if they're using an NDA where a perpetrator has been protected before. But could that even extend to one case of a very serious sexual abuse? And then the carrots rather than the stick, the gold standard employer. Well, the next generation are much less likely than we were, I think, to tolerate bad behavior in the workplace. The best employees want to work in an organization that not only values diversity and inclusion, but also one that properly protects its employees and is able to put up its hands when they fail to do so. The difference between a good relationship and a bad one. So an organization that's confident that it does that can be confident enough not to need NDAs. And if it introduced that as a policy, then it shows a level of transparency and progressiveness and can be a tool for recruitment and retention. I think that should be the gold standard that all employers are aiming for. And then we'll see far less NDAs. Now, I know that Emma is going to talk about some of the drafting points that lawyers can look at so that we can to reduce the impact of NDAs. But that's all I was going to say for now. Cristiano, if you want to.
Yes. Thank you very much. So thank you very much for the very clear situation of the rule and of the legislation in UK. I will leave the floor to Menaka Fernando. She's a partner of Outten and Goldblatt in the USA. Menaka, over to you.
Thank you very much. And it's such a great honor to be part of this panel. You know, I think it's really important to understand how global this movement has been, the Me Too movement. And I think one of the most important aspects of the movement was the fact that it brought this issue to the forefront and forced everybody, especially the legal community and the lawyers that are dealing with these NDAs on a daily basis, to really, you know, look themselves in the mirror and kind of understand the impact that we were having on our own clients and whether this was the only path. Because I think for a long time it was accepted as this is the only path. You know, an employer is not going to take this off the table. So why even ask? Why? And you know, it's incumbent on us to talk to our clients about why it's absolutely necessary to sign an NDA if they want to settle the claim. And I think the Me Too movement just kind of turned that upside down, turned it on its head and said, you know, this is part of the reason that these systemic abuses and these repeat offenders have been permitted to perpetuate this conduct. And, you know, the legal community has played a part in this. And, you know, thankfully, I practice in California, where, you know, generally speaking, the workers' rights laws are strongest in the nation and perhaps in you know, other parts of the world. As soon as the Me Too movement started in 2017, the California legislature took up a lot of bills around the issues of, you know, improving enforcement of our anti-sexual harassment, discrimination, sexual assault laws. And very soon in 2018, California enacted what's called the STAND Act, which banned the use of NDAs in sexual harassment and sexual assault cases. And then in 2021, we enacted the Silence No More Act, which expanded that to all forms of discrimination based on any protected characteristic in our anti-discrimination law, which is the Fair Employment and Housing Law, with, you know, with the kind of justification, why do we have to parse out? Because oftentimes, you know, these claims come together. For example, there's a lot of evidence that women of color, especially, are more vulnerable to sexual harassment. So you bring these intersectional claims of gender discrimination, sexual harassment, and then race discrimination. And the way that California's law read for a few years was for the sexual harassment, sexual assault piece of it, there could be or the victim could speak out about it, but then there could be confidentiality on the rest of the claim. So then the victim is forced to kind of parse out their experience when, in reality, it's the totality of the experience that has caused them to be victimized. So in 2022, when the Silence No More Act was enacted, that meant that any claim related to any form of discrimination would no longer be bound by an NDA. It's important to note that there is a little bit of a gray area where it is only limited to the underlying facts in California, and it's where an employee has filed an administrative charge or a lawsuit. And an administrative charge in California and in most jurisdictions, there's a requirement to exhaust your claims and file an administrative charge before you file a lawsuit. And these are very easy filings in California. It can just happen online. And the statute provides kind of for this middle ground where there still could be a more restrictive NDA, pre-filing before that kind of administrative charge. And then with respect to non-disparagement, oftentimes these non-disparagement provisions are also effectively NDAs, because what they say is that an employee cannot disparage a company, and disparagement is not a legal term of art. It's very broad. It just means that you can't say anything negative about your employer. And that often includes, by implication, your underlying allegations and underlying experience, which of course is very negative and it could negatively impact your employer. So these statutes in California very specifically also prohibit very broad non-disparagement provisions and require a carve-out in the non-disparagement provisions for any conduct or any behavior that the employee has reason to believe is unlawful. So it's very encompassing. It's not only the discrimination, it could also be like, not being paid their wages. It could be any kind of unlawful conduct. There needs to be a carve out there. In effect, what this has done, even though there are some limited areas where there can be broader NDAs, without kind of parsing out which situations fall in that category and which don't, for the most part, what I've seen is that since 2018, the evolution of the law has had the effect of, I would say 95% of the time, completely taking the issue of confidentiality off the table. We do not spend a lot of time talking about it because in most employers' standard release agreements, settlement agreements, and employers' councils settlement agreements, I've seen them just adding this language right out of the statute. It's very easy to do because the statute itself just kind of quotes, this is the language you need to put into your agreement. And it's just a matter of copy and pasting that language into the agreement so that there are these carve-outs for sexual assault, sexual harassment, discrimination related to any of the protected characteristics, and then a similar carve-out in the non-disparagement for anything that the employee has reason to believe is unlawful in the workplace. California is not the only state. There are at least about 20 or more states in California that have addressed this issue of NDAs and have had, made some sort of ban on NDAs. Washington State goes the furthest, probably in most jurisdictions globally, in that Washington not only bans NDAs, it also bans the request of NDAs. So an employer cannot even request an NDA without facing a penalty. It's like a $10,000 penalty every time an employer even requests an NDA. And so I think, this gets to the question of what Julie raised, which is employers are, and this is often what is the justification for not banning NDAs and taking things off the table, which is that employers are just not going to settle. And employers are not going to settle early if confidentiality is off the table. And I think, looking at California, because this, at least with respect to sexual assault and sexual harassment, those laws have been on the books since 2018. And then, we can start looking at the broader discrimination claims, and then in Washington as well, whether that's true or not. And I think anecdotally, I don't think that's the case. I don't think that employers are not settling, because I have not seen any impact on my early settlements, especially with respect to sexual assault and sexual harassment, because of these laws, because now employees can speak about it, and with respect to kind of the settlement amount. Again, this is anecdotal. I would say that my settlements have increased since the time that these bans have been passed. And, I don't know if there's any type of correlation. I do know that the Me Too movement, really put these issues in the forefront, and employers are still, they fear being in the headlines, and they do think that settling early is still beneficial to them. And on the flip side, I think that most employees that come to us have absolutely no interest in speaking about their experience on a large platform. Like, that is not the reason that they're reaching out to a lawyer. In fact, they probably have debated whether to take this step 100 times before actually taking this step. And, are extremely reluctant to come forward because they know what that means. They're opening themselves up. And I have clients that I'm representing right now that it took them a very long time to find that courage, to even to call us, and even to take that next step of like sending correspondence to the perpetrator's lawyer. I have clients that I've been representing for a really long time behind the scenes, just helping them make an internal complaint and go through that internal investigation. And these clients that have very valuable claims, meaning that they were being sexually harassed by high-level executives, that choose to walk away because, they would rather not be speaking out in this way. They would rather not, open themselves up. So it's just, it just kind of goes to show that there's not a lot of interest in employees broadcasting these, their experiences. But I think what it does do is it gives them a sense of agency to know that they have the choice not to be bound by an NDA. And I do think that certainly helps in giving them closure, making them feel like they've been empowered, and not feeling like they were pressured into signing something because of the money on the table. Because oftentimes, I mean, the money is good at that moment, but I think as lawyers, we forget that the trauma continues for a very, very, very long time. And we only see our client in this short time period where they've decided to hire us. And we don't, once they've signed on to an NDA, we don't see how that impacts them for the rest of their lives. So I do think that looking to California, to Washington, some of these other laws that are starting to be enacted in the US, and anecdotally, and doing more studies about how that's impacting settlements, if at all. And I know Zelda put in the chat, her organization has been tracking and has some data like from the EEOC settlement, that in fact, since the enactment of these laws, that in fact that settlements have increased by 9%. So I think it's important to do more of this research, so that what's happening in California, what's happening in Washington can be a model for the UK, Canada, and elsewhere in the United States.
Thank you very much. In the meantime, I saw that Zelda put some very interesting information on the chat. Maybe if you would like to say something later, because now is the time, last but not least, I would say, of Emma Phillips. She's a partner at Goldblatt Partners in Canada. Emma, please go ahead.
Good afternoon, everybody from Toronto, and thanks very much to include me in this panel. The situation in Canada is in many ways, I think, similar to the UK in that, of course, since the wake of Me Too, there's been very active coverage in the media about the propriety of using NDAs, but the impact of this debate on actual legal practices, I think, remains spotty. Several jurisdictions have explored implementing legislation, thanks to the hard work of Can't Buy My Silence, which, as we know, is co-founded by Zelda, and Dr. Julie McFarlane in Canada. So there is draft legislation on the books in a couple of provinces to restrict the use of NDAs, but thus far only Prince Edward Island, which is the very smallest of the Canadian provinces, has actually implemented broad-scale legislation, which is sort of similar to the California model. So in the rest of the country, including in Ontario, where I work, NDAs are still the default. There is increasing recognition within the legal community about the use of NDAs, and so the Canadian Bar Association passed a resolution by a margin of 94% to discourage the use of NDAs in cases of discrimination and harassment. But I think, as we heard from Julie, and probably as we've all experienced, the legal profession is fundamentally conservative on this issue, and it really remains difficult to convince lawyers in the absence of the kind of legislation that Menaka told us about. And in fact, when I've talked about the California legislation to other Canadian lawyers, there's sort of this look of surprise at how this could actually function. So it continues to be difficult to convince lawyers that settlements can be reached without access to these mechanisms. So in light of this, and given that Zelda was talking to us at the outset about lawyers' responsibilities to our own clients in these circumstances, I thought that I would sort of focus my comments on some of the strategies that I've been trying to use, and some of the legal counsel in Canada I know are trying to use, to try to at least rethink the use of NDAs without necessarily abandoning them entirely, again, at least until we have legislation prohibiting their use more broadly, in order to try to be responsive to at least some of the criticisms that have been levied against NDAs, and to try to address some of the power imbalances that Zelda was illustrating so forcefully. And I think what it really comes down to is, rather than treating NDAs as boilerplate clauses, we have a tendency to speak to it's almost like an on-off switch. You either have an NDA or you don't have an NDA. To try to instead approach them as a clause to be negotiated like any other clause in a settlement, which means that we can, on behalf of our clients, try to craft and tailor them depending on the particular facts of the case and depending on the particular interests of the parties. How do we do that? Well, obviously, that is the real challenge. But I've sort of boiled down my strategies into eight different ideas. I'm sure if we were to survey people on this call, we'd come up with a number of others. But the first is to, and I think this is the most obvious, restrict confidentiality to the terms of the settlement, not to the facts underlying the complaint. And Menaka already spoke about the fact that, in fact, most complainants don't actually want to, shout about the complaint from the, in the town hall, or like they actually want privacy, but it's the fact of the psychological harm of being told that they can never speak about it that is so oppressive. And generally speaking, of course, they're very comfortable with the idea that they can't disclose the lump sum payment or some other term of the settlement. And if limiting information is very important to the resolution of the dispute, then we can consider negotiating what can be said in the minutes of settlement instead of imposing complete silence, so that at least there is agreement about what the complainant and the respondent or the employer or the institution will say in circumstances, rather than that you have to just be absolutely silent. And this is, I think, particularly important in circumstances where, of course, there might be quite widespread knowledge about the incident in the workplace, especially if there's been an investigation. So everybody else is able to speculate and gossip about what's happening, but the complainant is the one who is silenced, and that can be particularly oppressive. The second is, and I hope by now this is a common sense, and unfortunately it wasn't in Zelda's case, but there should always be carve-outs for the complainant to be able to speak with family advisors, healthcare practitioners, union representatives, the support people that they need in order to be able to move through the process. Third, consider a sunset provision. Again, I'm often faced with surprise from employer counsel, resistance, but actually, I think this can be overcome, because sometimes it may feel that in this moment, confidentiality is critical, but is confidentiality really going to matter in a year or 2 or 3 from now? Oftentimes it really won't, once the controversy is over, the focus is over on this issue, people have moved on, and that can be psychologically really important for the complainant. Fourth is to limit the scope of the clause. So, you can have an agreement that says that the complainant won't publish any information about the underlying allegations in social media or in conventional media, but nothing restricts their private speech about it. That might be sufficient to address the employer, the institution's interest without being unduly repressive or restrictive for the complainant. I've also had clients who wanted to carve out for artistic expression. They wanted to be able to engage in songwriting or theater or other forms of artistic expression, or sometimes in research or participation in public dialogue in a broad sense, participate in public discussions or debates that are ongoing about, for example, the use of NDAs in cases of workplace harassment, as long as individual respondents or institutions are not identifiable. And certainly we shouldn't be including any retrospective obligations on the complainant, especially where they've already left their employment. Fifth, I'm glad that Menaka referenced the non-disparagement clauses. That's, I think, a real problem, because you may end up in a situation where you successfully negotiated out the NDA or limited the NDA, but then there's a non-disparagement clause, which is in fact broader than the confidentiality obligations. And in my experience, non-disparagement clauses are particularly stressful for complainants because they are so vague, and it's unclear what the boundaries are, and so it can feel even more oppressive to the complainant. So thinking about how to negotiate those, I mean, ideally not to have them, or to negotiate them in a narrower and more tailored way. In some circumstances, we've negotiated non-defamation clauses instead of non-disparagement clauses, because at least defamation is a clearly understood legal term and legal test. 6, consider a Jane Doe clause. Often one of the concerns that complainants express, and I think Zelda spoke to this, is about signing an NDA, is that they don't want to be complicit if the perpetrator offends again. They don't want to have participated in some kind of institutional cover-up, which just gives the perpetrator impunity to reoffend. So a Jane Doe clause basically says that the complainant agrees to maintain confidentiality, but if another employee comes forward with a complaint against the same perpetrator, the NDA is no longer binding. Or, you can have something that says the complainant in that case is not prohibited from participating in a workplace investigation or in a lawsuit into that new complaint. So they can add their voice and participate in that accountability mechanism. 7, I think we need to be much more careful and specific about the terms of penalty clauses, where at least in Canada, but I think in the UK as well, the law still is very conservative. Complainants should not be required to repay the entirety of the settlement if there is a breach of confidentiality. I think we have to remember, and this has already been spoken to today, that any monies that are paid are payment not just for a complainant's silence, although it might be partly for the silence, but to settle the underlying legal claim. And it's unreasonable to demand that the complainant repay the entirety of the amount in case of a breach. And finally, 8, and I was really interested to hear Zelda's comments at the outset, because it's very similar to what I have experienced, although obviously in much less high-profile circumstances. But consider negotiating systemic remedies in the settlement, because again, complainants may be much more interested in broader accountability than in any specific either financial settlement for themselves, or they might be more comfortable with the idea of confidentiality if they know that there's going to be a broader systemic mechanisms that are introduced. So that could involve improving mechanisms for complaints or investigation policies within the organization. It could include specific training for a particular group of employees or coaching for particular individuals. There may be other more specific types of systemic remedies that could be valuable and would allow the complainant to feel much more comfortable about limiting their ability to speak about issues publicly. Those are just 8 strategies. As I said, I'm sure there are others that we could come up with on this call, but I want to underscore, first of all, of course, that these are not complete solutions. They don't erase the harms of the NDAs that we've already talked about. They do allow for complainants to have some greater agency in negotiating an agreement that is reflective of their individual interests and not just the institutional interests. And I think the key step forward here is for lawyers to recognize that it is part of our professional obligation to our clients to explore these options, to help prepare them for what discussions about confidentiality will entail, and to arm them with potential options. And so it's a recognition that in advocating for what is in the best interests of our clients, we don't have to just be thinking about maximizing the financial settlement. That may be important, or it may be partially important, but terms such as terms about confidentiality and expression are also important to our clients. And so I think we need to be thinking about these as in balance with each other and not just an either or.
Thank you very much, Emma. This was really, really interesting. So now, Zelda, do you want to say something at the end after the evaluation, the consideration that they've done?
Well, there are lots of things that I can say, but I think, in fact, it's been an incredibly balanced conversation, and I think the facts speak for themselves. I think the facts show that the way forward is what's happening in America, and I agree absolutely with Emma that this is not about being one or the other. I think because our top line is always banning the misuse of NDAs, and we've got to reach for the furthest point, which is what people think of as a total ban. But actually, the reality is putting as much power in the victim's hands as is in the perpetrator's hands. This is a contract made between 2 people, and the victim should have choice. But one of those choices that should be taken off the table, which I do feel is about the integrity of law, is that you cannot have something legally enforceable that is hiding an action that can cause potential harm in the future. So to me, the litmus test is always that. I don't care what people want to carve out to keep confidential, as long as it cannot harm another individual in the future. I think having a time limit is also very important. That's putting power into the hands of the victim, giving them power over their own voice. And I think that if a victim wants a one-sided confidentiality agreement, that should also be something that should very much be considered, just as with sexual assault in the criminal realm, you have a right to anonymity. So I think some of the points that Julie made have already been answered in example from what's happening in Canada. What's happening in the States. And I think slowly what's happening in the UK is the law is moving incrementally around this issue to make it not possible. I think it would have been a lot simpler if they just took the option off the table. I think the duty on employers, and sorry for those of you not in the UK, but the duty on employers to proactively prevent sexual harassment is very important, but that's also an almost impossible task. I think one of the ways of showing, though, that you are actively trying to stop sexual harassment is agreeing to not use non-disclosure agreements and confidentiality to hide misconduct in your workplace. And I'm not plugging the campaign, but we do have a voluntary pledge for businesses to do that. And that's actually what managed to push legislation in higher education to stop the use of NDAs. So it's actually a very powerful tool, and it's a powerful message to your employees. And you know, again, there's another example this week with, you know, Julie mentioned Odie and we mentioned Fayed. But this week we can see that ITN have got in trouble, who provide all the independent news for Channel 4, Channel 5, ITV. And, you know, there is large use, which is now in the public domain, from an FOI of the use of NDAs, silencing journalists. And this just generally is becoming a subject that has to be grasped properly. And I really believe that the UK has a big chance to lead on this now. You know, the American bar, the Canadian bar have all voted against the use of misuse of NDAs. The British bar has publicly said it should be legislated against, but we're being very slow on taking decisive moves. And actually in that time, there's just more and more example of why it doesn't work, using confidentiality in an unethical way.
Okay, perfect. Thank you very much. So now we have some questions that we have already received that Julie is going to read us. But before, if there is anyone who would like to unmute themselves and ask any question to any one of the speaker, please go ahead.
I wanted to ask Menaka, based on what you've heard about the way the systems work in the UK and Canada, is there anything about how the system works in California that you think means that the legislation works there that might not work here? Because I think a lot of the lawyers here are still thinking we can't ban them in our jurisdiction, and it's, you know, it's incredible to hear the impact that the legislation has had in California, and that settlements are going up, and they're being individually being paid more. So I'd love to hear what you think could mean that the same could apply in other jurisdictions.
You know, I'm not obviously as familiar as you and Emma in kind of the ins and outs of the jurisdictions there, but just based on what a little bit of what I've heard, there are, you know, I think because the workers' rights laws are so friendly in California, there are a lot of employees that do bring claims in California, and I think, you know, employers almost expect it. So it becomes, you know, it's oftentimes part of kind of the business discussions and operations of running you know, a workplace in how to handle these situations. So I think that maybe employers are not as surprised, and it's public. Like once you file with the administrative agency, the California Rights Department, or there are other administrative agencies for kind of wage violations. Even though it's not something that you can find on Google, it's considered a public filing, and my understanding, at least in the UK, like even if you file in tribunal, it's still private. So an employer for a long time can have the expectation that this is going to be a private situation that's dealt, you know, very confidentially, even if there is that kind of filing of a charge. And in addition to that, you know, there is a fee shifting statute that governs sexual harassment and discrimination. So that limitation for an employee, the cost prohibitiveness, where, you know, they might not take that step, doesn't really exist in California, although I mean they do have to think about the fact that if they lose, they might be responsible for some of the costs. But at the same time, you know, because there's fee shifting and because the employer is usually going to be on the hook for attorney's fees, if they prevail, and it's only in the rarest of circumstances that an employee would be on the hook, and that almost never gets enforced by the courts. You know, it's more there's more incentive for an employer to kind of do more to enforce these laws and fix these issues, and an employee, you know, is probably less reluctant to take these steps. And so there's probably more of kind of a collective, you know, collective request and kind of consensus that this legislation just makes sense in a place like California, where there is a lot of, you know, there are a lot of these lawsuits and not a lot of the restrictions for making these situations public as there might be in other jurisdictions. But at the same time, I mean, I think that, you know, some of the same arguments do apply. And I think that, you know, it's still a good model in countering some of the arguments as to why NDAs in the UK or Canada, you know, might not work.
Thank you. Emma, did you want to say anything?
I think the experience is that unless and until there's broad scale legislation, it doesn't. It's just really hard to shift the mindset as much as, you know, we're coming up with our strategies and trying to be creative. And the only other comment I wanted to make is there's, for very good reason, a lot of focus on NDAs specifically as an impediment to accountability. But the experience in Canada is, you know, there are other mechanisms as well that are hugely important to addressing the issues of sexual harassment or discrimination in the workplace, which are not being given, I think, enough attention. And so if we're actually concerned about addressing either preventing or addressing after the fact sexual harassment, we need to be paying attention to NDAs, but we also need to be paying attention to, at least in Canada, funding for human rights tribunals, which are the body that hear these complaints and which have been gutted of you know, appropriate adjudicators, et cetera, to be able to, and those are financially accessible mechanisms rather than the courts, where you can actually go and you can self-represent and you can address these issues before an adjudicator who's got binding authority. And if those mechanisms are gutted of their power, then we're, you know, we might have great NDA legislation on the one hand, but we're actually completely removing the ability of complainants to enforce their rights on the other hand. So I just kind of want to throw that in, that the discussion about NDAs is hugely important, but I don't think we should be so myopic as to lose sight of the other ways in which we can also address and prevent sexual harassment.
I have heard that in the UK there was some slightly different point, but there's been a consultation in financial services which has required all regulated employers to provide details of the non-financial misconduct settlements that they've entered into in the last, I can't remember over what timescale, but it's forced a lot of boards in financial services companies to actually look at the number of settlements they've been entering into, the number of NDAs. And I understand it may well lead to a new level of accountability, because I kind of almost feel that for the employer's solicitor, they are, if they're going to not put an NDA in a settlement agreement, it's almost got to come from the client rather than the employer's solicitors making the decision on behalf of the client. And so if the client is, I mean, I understand, you know, the employer's solicitors have their regulatory duties, but I feel like if the decisions can come from a board level to limit the use of NDAs, and that's another path to stopping their use absent legislation, although I'm not hopeful that that's going to go anywhere very quickly. So yeah.
Just have a couple of very tiny things to say as in being in the enviable position of being the only layperson here, is that I know when, and the majority of people I know listening are lawyers, but I think one of the things that we need to keep an eye on, as Emma is saying, is that this is much, much broader. And I know this, what we're talking about today is specifically in relation to sexual harassment. And it may surprise some of you who don't know about the work that I do, or that Julie and I do, is that we are not limited to sexual harassment. This is not really just about sexual harassment. Sexual harassment is just what has caught the zeitgeist and the common interest. Again, for me, this is about the integrity of law. And NDAs are being used in every single sector. They're hiding faulty baby formula, faulty building products, malpractice in the medical world and in the legal world. And the point is that to make broad-scale cultural change, you have to move away from the legal minutiae and actually make a bigger, braver decision about how to use the law. If you take away confidentiality around misconduct of all types, you also are immediately nudging and changing society's behavior. Because if the option to hide something isn't there, people will alter their behavior. You can't tell people not to be bad, but you can make it easier for them not to be bad. And I think this is one of the things that we often lose sight of when we're talking about the minutiae of how to make an ethical NDA or how it doesn't work in certain situations. I think we have to be braver and look at this in a much broader way and look at it more about the ethics behind what confidentiality and the law, how they work together and how they're used, and how the reality of the world is that people with power and money are always going to have access to wielding the law in a more creative way than those who are vulnerable. And that's just never going to go away.
I think that brings us to the end of our questions, unless Emma or Menaka, you had anything else you wanted to raise?
I think that's an excellent note to end on.
Yeah.
Call to all of us to be more aware of those dynamics.
I would like to thank you everyone to have participated to this wonderful, very interesting meeting. I would like to thank you also our speakers once again for your invaluable contribution. Today we have heard about the significant challenge posed by NDA in sexual harassment settlement, and we have also discussed possible ways forward. Whether through legislation, advocacy, or ethical lawyer, we all have a role in ensuring that NDA do not become a tool for perpetuating silence and harm. So thank you to everyone for joining us today, and I hope this discussion sparks continued conversation and action in your respective jurisdiction. Thank you very much.